Welcome to Agency Bytes, a podcast for agency owners, hosted by agency veteran and coach Steve Guberman. Agency Bytes is a podcast focused on delivering actionable agency information from agency experts in about 25 minutes. Why 25 minutes? Because who has the attention span for much more these days? And you can squeeze in a listen between meetings with time for a bathroom break or coffee refill before your next meeting.
Welcome to Agency Bytes, podcast for agency owners. I'm Steve Guberman from Agency Outsight, where I coach agency owners to build the agency of their dreams. Today, I'm really excited to be joined by Gabe Levine from Matchstick Legal. So he's an attorney specializing in representing creative and technical businesses in commercial transactions. You're a shareholder and president at Matchstick Legal out in California. And Gabe, thanks so much for joining us.
My pleasure. Thanks for having me.
Yeah, real excited. For me, part of the excitement is I can remember kind of hearing your name dropped a few times, 10, 15, whenever it was years ago, with Mike Montiero and his, fuck you, pay me talk. And thought at the time I had my agency and thought, wow, this guy's got a relationship with a lawyer that I don't even know that I have as close with, like, my brother, or you know what I mean? Like, it felt like as a business owner or an agency owner, having a relationship with an attorney just made really good sense. But it was also like, how often should I be using my attorney as an agency owner? And I'm not. So there was definitely some like imposter syndrome lining up there where it's like, what am I doing wrong? But so yeah, super pumped to have you here. Thanks for joining me. How are you?
Yeah, I'm good. Really good. And Mike is a marketing genius because I think that's the exact response he wanted in people's heads for both himself and me. And I think it worked.
Yeah.
The talk that keeps on giving 13 some odd years later. Yeah.
Now, Matchstick and your practice, have you always been in the creative space? What's the journey been there for you?
Yeah. Quickly, I graduated law school in 2003. I started at a big law firm doing mostly, management side employment work. Didn't really line up with my politics, but alas, I wanted to be a trial lawyer. And there was a path there. 2 years at that place was enough for me. Went to a small firm in San Francisco where it was more of a generalist and representing smaller businesses, doing all sorts of things and individuals. And so that was 2005. And then shortly after joining that firm, I got my first referral, and it was Mike and Erica of Mule Design. And so they were my first client that I owned. And out of working with them and their sort of notoriety and connections in San Francisco in 2005, when sort of the web design space was burgeoning, I got a nice little cadre of clients in that area. And grew a little practice. And in general, those folks were much nicer to work with than some of the other stodgy business clients I had, and had been working with. And so I fostered it and tried to make those connections. And it was easy at the time, being in San Francisco and 30 something. And then that grew, in 2011 with the talk and sort of expanded. And after that talk, which was viral as fuck back in the day. And Mike knew amplifiers, lots of them, John Gruber and people who just put it out everywhere. I actually got contacted by a number of attorneys too, just to be like, hey, I want to meet you. I want to thank you or whatever. And one of those attorneys was Josh Barrett, who's now my business partner. And I spoke with all those attorneys and but Josh was like, I'm like, this dude's solid. And he had been at a sort of mid-sized firm in Portland, Oregon, where he still lives and works, doing more corporate work and mergers and acquisitions and stodgy stuff. But at the time, to hear him tell it, his kids were in elementary or middle school, and Portland was full of designers, as it remains. And he went out on his own, and because in part those people were coming up to him and at the line to drop their kids, like, hey, have you seen this video? I need a lawyer. And so he started his practice at his law firm, which was called Create Legal at the time. And we just sort of formed a relationship and worked together, and then eventually merged our practices. And I had left that small business firm shortly after 2011 for various reasons, and kind of gone out on my own. And so we merged our practices and our firms January 1st, 2019, and here we are.
Awesome. All right. So it's only been 4 or 5 years now that you guys are merged and firing all cinders. Yeah.
Going on 5.5 years now. Yeah. And it does feel fast, but also 5 years. Good.
Yeah, that's awesome. Congratulations. Yeah, you hit that 5-year mark and it's like, all right, I can take a breath. We hit that first milestone, and yeah, I get that. So legal things that I definitely wanted to dig into that I think are kind of front of mind hot topics in the industry these days, and kind of get your feedback on. One of the things that's always been pressing, in the creative space is like, how do we protect our work from copycats? I have a friend, Dan Antonelli. He was on here, I guess a handful or so episodes ago. Big branding guy. He does a lot of home service trucks, fleets of trucks. And here in New Jersey, where he is, and I am also, we see copycats on vans all the time. And, he's got this ongoing Facebook rant about people stealing his work, and, his lawyer, he's always tagging him on the Facebook post. And so how much recourse is there? Like, what are some things that we can do to protect ourselves against the copycats and thieves out there?
Yeah, it's an interesting subject, of course, and evergreen, like you say, for agencies that are, providing these services to their clients. And what you're talking about specifically with your friend, it's really a trademark issue. So it's like the logo or branding or name that was designed and created for that company, that brand. And the best thing they can do is actually try to register that trademark and protect it. And so you do have to make decisions, strategic decisions, money decisions about how aggressive you want to be about that, and who you really want to try to go after if they use your brand. And registration with PTO isn't a total shield or a total sword, but it's very helpful. And you can't always get it because there might be something that exists that actually predates you that you don't know about. So there's a little diligence you can do before picking your brand too, that any trademark lawyer and frankly, just, paralegal or even non-professionals can do to research whether or not their new brand name or logo might be protectable and usable. And then of course there's, on things like copyrightable works, which are more on the art and written side, code too, but we don't need to get into that. You can register a copyright. It's pretty rare in client work for anybody to do that. So generally, but I do see it come up, and people who are more independent, sort of artists and creators do copyright some of their works to get that protection. And that is something you have to do in sort of a time limited fashion, about 3 months after you release the work to get all the remedies you need from a copyright standpoint.
Do you see agencies have that kind of registered research or trademark research in their process, or do they push it off to the client? Like, we came up with something beautiful. You like it. We like it. Go figure it out yourself.
Much more the latter. But, big branding agencies, typical agencies do more of that work. And we do have clients that do that work. They won't get the registration, but they'll do some searches and provide maybe and we certainly do plenty of this too, but provide a high level report of green, yellow, red, and most of the time it's going to fall in yellow. And then let their clients make choices from, the green and yellow options. And if the brands aren't sophisticated enough, there's probably some level of advice like, hey, you should do something to protect your brand. But more often than not, I think the brands that our clients and agencies are working for do have that level of sophistication where they're doing the trademark clearance, searches, registration on their own behalf.
Yeah, their process is advanced enough, or their clients are on that level where there's the level of sophistication. Maybe they even have in-house counsel or something along those lines. They're handling it mid-process. I've definitely seen enough you get to that finish line and it's like everybody loves the work, and then they do a search and it's like, we can't use this. This is too similar to something that never came up, or
and that's a really sticky wicket from a contract standpoint.
Yeah,
fees, payment, time sync standpoint that we've worked with a lot of clients to negotiate and try to build processes around that are fun, like fair and interesting, and work symbiotically with the parties, rather than just kind of like, oh, agency, sorry, we're not going to pay you because we can't use this, or you have to redo this, or you have to fix this, or something like that.
Do you typically see that like if those precautions aren't put in contractual or early enough, do you see that falling on clients saying, agency, you should have known better, agency, you should have researched better? Like, where does that typically fall?
I mean, from a non-contractual perspective, I think the client is always going to be pissed like that and be like, what did you give us? From a contractual perspective, it really depends on how the contract's written and whose contract is being used. If an agency is just taking a larger brand, a larger company's contract, it's going to be on the agency. If we've written the contract for the agency, it's going to be on, the brand, unless, somebody at our client copied something and knew about it.
Yeah.
Yeah.
You see that a lot? I can't, God, that makes me nauseous just thinking.
No. We really don't. No.
Good.
I don't know that I've ever in nearly 20 years in the space seen like, oh shit, our designer copied this, client discovered it, help.
Yeah. Yeah, that's not good. So talking about contracts and like the protections that an agency needs to put in place, from like copyright, IP, ownership, release of ownership, things like that. Joking before I hit the record button, not joking, but a little bit, I had a contract in place. It was, my AIGA standard contract that I took and kind of, reused for myself. We had that in place for the entire decade I had my agency, with modifications here and there. How often are you seeing agencies need to review their terms of contracts and make sure they're modernized?
A good contract, I think, can live for 3 or 4 years. It's better to check up more often than that. It's not so much laws changing, but businesses changing and practices changing. Any growing, even established business changes the way it works with clients, professional services business, monthly. So what we end up seeing is that a lot of the contracts that are being used don't fit. It's a bit square peg, round hole. That does tend to fall more into the statements of work and the project-based attachments than it does necessarily the main services agreement. But I think that's a good rule of thumb, is that, it's something you might check in on at a minimum every 3 or 4 years.
Yeah. So I try to help agencies kind of simplify their process, whether it's if you can simplify it for biz dev, that's just a smoother process. If you can simplify it for account management, that's just, better for everybody. And some agencies, when I start working with them, they've got 3 and 4 contracts. They've got, a scope of work separate from an MSA, separate from a, contract, separate from I don't even know what else they've got. Is there like, you should, always break this out from that, and each project should be its own separate scope, or like, what are your kind of rules of thumb on that?
The optimal situation is that you can have one standard set of terms, be it a contract or a set of terms that lives online, even as things are doing these days. Mm-hmm. And then you have project-based documents that describe the business terms for that project. I think that's the optimal way to do it. So most of our clients, not all, but most of our clients want a longer-term relationship with their clients. So you kind of negotiate at the front, or adopt at the front the set of standard terms, and then set it and forget it.
Yep.
For a while at least. And hopefully, if you're the agency, a long while, so you don't have to renegotiate. Yeah. And then you put in place, the statement of work or scope of work or whatever you want to call it, work order for specific projects. But some people need different contracts for different types of work. I mean, maintenance, sometimes hosting maintenance, whatever, what have you, can be have a different level of needs. But we almost always are able to cover an agency off in one standard agreement with separate statements of work.
Yeah, I think that keeps it super clean and simple in that way. Yeah, you can extend that relationship out and not have to renegotiate every time. And, oh, you need a new brochure or a new, campaign comes up. We can do, a statement of work with scope, deliverables, timelines, just for that specific, project each time. And it always refers back to the overall MSA contract of this is how we work. These are our expectations, ownership rights, termination clause. Termination clause. This actually came up with a client yesterday. Terminations and reactivation fees and clauses. What are your feelings on reactivation clauses and fees?
Yeah, so the pause clause.
Pause clause, yeah.
I think I adopted from Carl way back when, 2012 or 13, Carl Smith at the Bureau, back when he was Engine.
Engine works.
So I think termination provisions are extremely important, in part or mainly to provide leverage if and when a relationship is breaking apart for whatever reason, or a project is breaking apart, not necessarily even a relationship. And the pause clause is a related thing that is there for when the client typically delays, or you have another situation where the client has, made it impossible for the agency to continue its work. I think it's perfectly reasonable. I think it's a little hard to define sometimes because, you might just say a percentage of the project fee. That doesn't always line up with how the SOW is structured, where you are in the project, what might actually cover the agency's losses. I also think it can be problematic if you don't word it correctly, because you can't necessarily just snap the team back to work just because the client pays $5,000 on a $50,000 project. You need to be careful to word it such that, hey, if you're not giving us what we need, and this is a continuing or big problem, we'll tell you in plain English, and then you got to fix it. And if you don't, we're going to have to stop our work. And to restart, we're going to need to probably rescope, and we're definitely going to need some compensation for that restart. So that's the plain English way of saying it. And then you got to MacGyver that, lawyer it into appropriate words, which don't need to be that different from what I just said. They don't have to have Latin or 4 syllables in there. But that's the concept. And I think it's reasonable and fair. And I think it's a decent thing to be thinking about protecting yourself against.
Yeah. The thing that to me that's mind blowing about that is how clients have a hard time understanding that, well, we dragged our feet for a month or 6 months. Why can't you just jump back in now? And it's like, well, because we've got a team to keep alive. So we've put other work in place. Now that work takes priority over the stuff that you backseated for 2 months, 3 months.
Yeah, I mean, it's really funny when I have clients. I have some very successful clients that do things like with smaller brands, and not even necessarily smaller, just more like, they're not public companies. They might even be brands that are kind of public companies, but they're not tech, they're not financial, they're not health, they're not highly regulated. They're a clothing brand or something, and it's just so much easier to deal in general with those folks on contracts because they get it and they operate like actual businesses with a conscience, as opposed to larger businesses, highly regulated industries, public companies, which operate more like a machine. Not to get too political, but like just with the capitalist goal of maximize money, which fine, that is what it is, but it really impacts the analysis of a contract. And one of the things that we frequently do is we'll get on a call at a stage of negotiation of a contract, a meeting, face to face, although many lawyers at big firms won't turn their cameras on, surprisingly, and talk through with the clients and the lawyers, right? With the business folks and the lawyers. And it is amazing how often, with high predictability, the business folks will say, oh, when you explain it, something like this, that's a reasonable, like, yeah, that makes sense. And their lawyer's like, well, So, but yeah, I digress.
Yeah. No, but you're absolutely right. Like from a concept standpoint, they know what they're doing is wrong, and they know that what their expectations are are just unattainable. And so when you back them into a corner, they're like, yeah, we stuttering lawyer on a Zoom call.
It doesn't always get to that real point, but it can be helpful.
Yeah. Yeah. What are your thoughts on, GDPR totally upended marketing in the EU a bunch of years ago? What are your thoughts on that kind of hitting? I know California started to implement certain regulations as they do for everything. What do you think about that being like a widespread thing here in the US?
Well, it's interesting. So the California law has sort of threshold requirements that only apply to larger businesses. I like that. Mm-hmm. Or businesses that deal in selling personal information. I like that because I think first of all, I think that the folks enforcing GDPR, the enforcement agents, are only going after larger targets in general. And that was sort of the intent. It doesn't mean you can completely flaunt the law, but it doesn't make sense as applied to some smaller businesses that are doing limited collection or processing of personal information. I like California's approach better than GDPR. I do think that the regulation is necessary in general, that people's privacy rights are important. As with much legislation, I think it's a little bit of both an overreach and a poorly thought out thing. But in general, I think it's where we're headed. And I think more clearer choices, not just things that are out there to satisfy laws, but clearer choices would be good. However, on the other hand, I think most of us, including myself, now live in a world where we're like, I don't have privacy on the web. Right. We know that. We know every transaction and button we click and everything we look at is monitored by at least 3 or 4 different large companies and their service providers. So I think there is a balance of that reality with what the regulation can even be. And I think that a lot more technological tools that are better designed by people who really care about privacy would probably help. Some more standardization of the actual tools that folks use. It would certainly help our agencies. They're like, how do we even do that? How do we do that? Those are my events.
So it's almost like it's like in the right direction because it's not overarching and oversweeping, but it's also almost like it's too little too late because our cats are all out of the bags. They're all over the internet. The data is already leaked and databases that are being sold left and right. And so what's the point, right?
Yeah, maybe. There's still a point. We can still, maybe protect our kids. I don't know. We should have all been like our parents with the little, covers on the the sticky notes on the camera. I think it's good. I think it's a good thing that society is doing. Legislators and the world over will continue to fuck it up and fix it, and that'll happen. And people. Thankfully, I have not seen the big agencies get in trouble for it, really, at least the agencies we work with. It is a pain in the ass from a contract and policy standpoint. And clients, particularly highly regulated public companies, large clients, just require absolutely unrealistic things in their policies that our clients are like, and I can read them and go, I know you don't do this, do you? Like, yeah, we don't do that. So that's a bit of a pain in the butt that you have to decide how much you want to pay attention to.
Well, it's not too dissimilar with some of the insurance policies that corporate requires of certain agencies, not too dissimilar to some of the cybersecurity guidelines, things like that, So, I think they're all a little high expectations on those things.
Yep. You froze a little bit. You can edit this part out. Guidelines was the first thing I heard there after my reply. Yeah, the unrealistic guidelines from larger companies for sure.
Oh yeah, larger. So some of the unrealistic guidelines from larger companies between insurance policies, cybersecurity policies, all of that. From a 10-person, 20-person agency, you're asking for
my agencies that have well over 100 people don't comply with those things. Not even close.
Yeah.
Yeah.
Yeah, some of the small agencies are like, wow, we can get into the Amexes of the world, but we have to jump through these 9,000 hoops first. And it's like, you don't want to do that. Yeah. Not worth it.
Yeah. Procurement.
That'll crush your agency before you do it.
Well, it'll crush your soul temporarily, at least. Did you catch that?
So I'm going to jump gears real quick. Couple random rapid fire questions for you. Answers to which can be personal, professional, anything in between. And so first is, what's something that you can't get enough of these days? You're binging either, a show, a podcast, a book, a hobby, whatever.
Gravel biking.
So what's gravel biking? Is that just like rail trails?
It's a good question. For me, it's largely taking a rigid bike without suspension with drop bars up and down the dirt roads on Mount Tam.
Okay. But
it's anything that's off-road on a drop bar bike without a suspension, generally speaking. And even that's getting mixed. So I got into it maybe close to about a year ago. And I love it. I can't get enough of it. I am training for my first 100-mile race, which my only goal is to finish within the time limits, because it's going to be hard. And the people who do this shit are ridiculously fit. But it's made me a lot more healthy, and I get my fill of the outside. I used to trail run a lot, but I've got a torn labrum in my hip, and running is not in the cards right now. So this has been filling the void for a while.
Good for you. Yeah, I think that kind of activity, exercise, goals, absolutely. What does that do for kind of mental health and breaking away and all that?
Yeah, for me, they're part and parcel, like I think a lot of humans. And exercise in general, but really getting outside. I'm really fortunate where I live. It's gorgeous here and conducive to being outside. And so that, it's not everything for my mental health. There's a lot of other important components, but mental, physical health, it's certainly a huge chunk.
Yeah, that's awesome. What's something that you've integrated into your life, your workflow, again, digital or physical, that you look back and you're like, how did I survive without this thing?
I am such a slow adopter of tools, much to the chagrin of the people I work with. I'm trying to think, how did I work without this? Man, it's going to sound super email. Email is, and I guess it was kind of there when I started, but we were still writing letters and faxing them. Yeah. Email is 50 to 75% of my daily work any given day. The rest is just done in contracts. It's a lame answer, but it's the truth.
Do you guys, like the medical professionals is still using fax for security? Do you guys do faxing for security still?
Oh God, no.
Okay.
No. I'm not even sure it's more secure. There's a piece of paper laying around there. I guess you're not losing the data in the ether, but is that even true? The image is translated over some line somewhere.
Yeah, I don't know. So typically I'll ask for what's an invaluable piece of business advice. In your case, what's an invaluable piece of legal advice? Not that this can be used as legal advice, whatever that disclaimer is, but what's something that's like, the lawyer says do this, you should do this.
I won't even go there. I would say have perspective on what's important and not from a legal standpoint. There are some things that just aren't. More often than not, I'll be honest, I think that those security terms are probably not going to come into play. Mm-hmm. But the provisions in the contract around getting you paid, those are important. Have perspective around what you can and can't negotiate in your leverage. Create the leverage. You can't negotiate if you're not willing to lose the deal. So do what you can in your business to create the leverage and then use it. Perspective and negotiate where you can. But if you can't and you need the work, obviously your lawyers and your business partners and your friends and your employees don't want you to sign any contract, but sometimes you gotta do what you gotta do in downtime. So that's the perspective piece. And then, create that leverage if you can and know where to use it and exercise it. Sometimes that requires working with an attorney or, operations people, but yeah.
Awesome. Gabe, I'm really grateful for your time. Thank you for joining us. I appreciate your experience today.
My pleasure, Steve. Thanks again for having me.
All right.
Thanks again for tuning in to Agency Bytes. If you know someone with expert knowledge on a topic that agency owners would love to hear about, go to agencyoutsight.com/podcast-guest and nominate them.